Awesome. Well, in the interest of time, so we can get to the content, I'll go ahead and get us started. My name is Raya. I am one of the program managers for Doctors for America. I've had the honor of working with Connor and Lorena here on the Know Your Rights guides for the California Shield laws. And so, just very quickly, I wanted to invite you guys all, if you're not already, to join DFA and become a member. It means basically taking the important step of selecting a membership and paying annual membership dues to support DFA's organizational sustainability and incredible programs like this one. And I will drop a link in the chat shortly for you to do that if you're interested. And I just wanted to let you all know that we are recording this for folks to watch later, and all the materials will be available afterwards. You will get a email notification about that. And then finally, this is a educational session, so there's two quick ground rules. There's no such thing as a stupid question. And speaking of questions, we'll use the Q&A feature to address your questions. So later, after the presentation's over, if you have any questions, please use the Q&A function, and Connor and Lorena will respond as they can. And I just want to quickly introduce you guys, and then we can get started. So, Connor or Lorena, whoever wants to get started, you can kick it off.
Thank you so much, Raya. And hi, everyone. My name is Lorena Garcia Zermeno. I use she, her pronouns, and I currently just finished my second year at UCLA Law and had the privilege and honor to work with UCLA Center on Reproductive Health Law and Policy and Doctors for America this semester, working on these really incredible guides for clinicians on California Shield laws. And with that, I'll pass it to my colleague, Connor.
Thank you, Lorena. I'm Conor Danaher. I guess I can't say I'm a 3L anymore. I just graduated from UCLA Law last week. Grades haven't come out, so we'll see how those go. But I've also had the privilege of working as a legal extern at the Center on Reproductive Health Law and Policy, and um, absolutely loved working at the center and on this important project with Doctors for America. And I'm really excited to be here today to talk to everyone about California Shield Law. So with that, I will pass it back to Lorena to get us started and to talk about the agenda for today.
Okay, that looks great from our end. Yeah. Thank you, Connor. And again, just wanted to say thank you so much to Raya and Doctors for America for the introduction and the opportunity to present today on California Shield laws and the protections that they afford for reproductive and gender-affirming care for California clinicians. And as Ryan mentioned, and we introduced ourselves, so my name is Lorena, and my colleague Connor and I will be diving a little bit more deeply into the specific protections of California Shield laws. And so a little bit about our agenda for today. So today's presentation, we will be sharing a little bit more about who we are at the center. We will be providing an introduction to shield laws, the current legal landscape, and why shield laws are important. We will also dive a little bit deeper into providing an overview of California shield laws, the specific protections that they afford, and we'll also share a few additional considerations and next steps for clinicians that are interested in providing abortion or gender-affirming care to patients via telehealth. And so who are we? Connor and I had the honor of externing with UCLA Center on Reproductive Health Law and Policy, and also collaborating with Doctors for America to create a shield law guide specifically for California clinicians related to reproductive and gender-affirming care. So I know the guides are not yet published, but we will send them to all participants once they are available. And a little bit about the center. So UCLA Center on Reproductive Health Law and Policy is a think tank and research center developing long-term, lasting solutions that advance reproductive justice and address the current national crisis of abortion access. And so we do this through innovative work and collaborations on legal strategies, policy solutions, and research on some of the most complex issues facing women, pregnant people, and families today. And so an important disclaimer before we dive into the provisions. So This presentation does not and is not intended to constitute legal or medical advice. So nothing herein is intended to create and does not form an attorney-client relationship. And all information, content, and materials are for general informational purposes only. If you need any legal advice for a specific problem, please consult an attorney. And in regards to that, we wanted to flag that if you are looking to consult with an attorney on particular questions that you have, UCLA Center on Reproductive Health, Law, and Policy through their Southern California Legal Alliance and Reproductive Justice, for short, SoCal Large, they provide free legal services for reproductive health providers, patients, and advocates. And so I know we will be adding that information for for SoCal Large in the chat. And so if you do have any questions, please feel free to reach out to them. There's amazing folks on the team that can help you with answering your specific legal questions. And with that, I'll pass it to Conor.
Great. So I'm going to talk a little bit about shield laws in general and give a bit of a primer on them before we jump into the specifics of the protections under California shield laws. So generally, shield laws arose primarily in response to state efforts to restrict and criminalize abortion after the U.S. Supreme Court's decision in Dobbs in 2022 eliminated the federal constitutional right to abortion. And shield laws were really designed to protect clinicians, patients, and others who assist in providing reproductive and gender affirming care, who we will refer to in this presentation as helpers, in states where that care is legal from the reach of states that have criminal, civil, and professional consequences related to that care. So shield laws really protect people from criminal, civil, and professional consequences that are based on violating another state's restrictions or bans on reproductive or gender affirming care. So this slide just gives a little bit of an overview of the current shield law landscape across the states. So you can see here that currently 22 states, as well as the District of Columbia, have some form of shield law established either through legislation or executive order that protect reproductive health care, and 18 states, as well as DC, have shield laws protecting gender affirming care. And the extent of the protections offered by each jurisdiction varies quite a lot. So, for example, only in 8 states do shield laws explicitly protect the provision of care regardless of the location of the patient. So that explicitly protects the provision of care by telehealth. Also, kind of an important wrinkle is that some states that have generally restrictive laws regarding reproductive health care or gender affirming care still have shield laws that protect the provision of that care to the extent it's legal in that state. So, for example, Arizona is an interesting case where the laws are pretty restrictive, at least with respect to providing gender affirming care to minors, but the shield laws in Arizona still protect clinicians providing care to the extent it's legal there in that state. So our presentation is going to focus on California's shield laws, but if you'd like to learn more about the protections offered by the shield laws in other states, our center does put out a great guide describing the protections in other states, and we'll put a link to that guide in the chat so you can access it there. And I see it's just gone into the chat, so perfect timing. A little bit about why shield laws are important. So as you all, I'm sure know, we live in a time where both abortion and gender affirming care are heavily restricted and regulated in many states. So 26 states currently ban or heavily restrict abortion, and 27 states restrict youth access to gender affirming care. And shield laws are really important legal tools that help patients in those states get the care they need, the reproductive and gender affirming care they need, either in person or via telehealth. And in addition, by protecting care provided by telehealth, shield laws allow more people to access care more easily, including people who are living in rural areas, people with limited resources, other people who have difficulty traveling, survivors of intimate partner violence, people with disabilities, and people in underserved communities, including Black and Brown communities that face additional barriers to receiving care. So now we're going to dive into California's shield laws specifically, and I'll pass it on to Lorena to start to talk about the specific protections in California's laws.
Thank you, Connor. Uh, really quickly, just wanted to flag. So I know that we will be giving an overview of California's shield laws. For further, like more detailed, nuanced information, we would like to encourage you to consult our guides that are intended for clinicians once they are published. But in the meantime, as Connor mentioned, we have some additional resources that have been created by UCLA Center on Reproductive Health Law and Policy that went into the chat. So please feel free to reference those in the meantime. So in terms of common shield law scenarios, there are two common scenarios in which California's shield laws offer protections, and we really wanted to lay these out to kind of anchor the conversation as we describe the specific provisions. And so in the first scenario is when a California clinician offers abortion or gender-affirming care that's lawful in California in person to a patient who traveled to California from another state. So in other words, this means that both the clinician and the patient were located in California when the care was provided. And the second scenario in which shield laws would apply is when a California clinician offers abortion or gender-affirming care that is lawful in California via telehealth to a patient that's located in another state. And this includes prescribing and sending medication abortion or gender-affirming medications like hormone therapy or puberty blockers to a patient that's located in another state, so outside of California. In this second scenario, the clinician, again, is located in California, but the patient is located out of state and receives care via telehealth. And so now we're going to walk you through the five categories of shield law protections, and we'll also be providing some hypothetical examples to really try to demonstrate and impact how these protections apply and some of their limitations. And so the five categories that we'll be discussing are one, protections against out-of-state investigations and prosecutions, two, protections against civil liability, three, protections against professional discipline and restriction of facility privileges, four, protections against adverse consequences regarding professional liability insurance, and five, protections for privacy of medical information and other data related to reproductive and gender-affirming care. And so for the first category or bucket of protections that we wanted to go over is protections against out-of-state investigations and prosecutions. And so there's kind of three general areas of protections. The first is California bars state agencies, employees, contractors, or agents from cooperating or providing information or using resources to help an investigation of a legally protected healthcare activity. And so a legally protected healthcare activity in this case would include reproductive health care and gender-affirming care that is legal in California, regardless of where the patient is located. And so the second area protects against extradition and arrests. And just for some, I think, to define a few terms, extradition refers to the process of delivering a person to another jurisdiction, which essentially means delivering somebody to another state for prosecution. And so California shields clinicians that are located in the state of California against arrest for providing gender-affirming care or reproductive health care that is legal in the state of California. Also, important to note that law enforcement may not extradite clinicians for violating another state's laws regarding gender-affirming care and reproductive health care if that care is legal in California. And I think an important thing to flag is that the provisions on extradition in California, they were issued through executive order. And there are current attempts to pass these provisions through legislation. And I think the reason why this is important is because executive orders are a little bit more subject to change depending on who is in office, whereas legislation is on a more solid footing. And that is something I think important to track and keep in mind. And the third area really protects against the issuance of search warrants, subpoenas, and witness summons. And again, to clarify what some of these terms mean, a search warrant refers to an order from a court authorizing law enforcement to search a person or property for evidence. A subpoena refers to an order from a court to provide evidence or testimony. And so this last category really, the protections are meant to ensure that search warrants and subpoenas that they cannot be issued related to an investigation into gender-affirming care or reproductive health care, and also ensure that California judges may not order a witness to appear in court. And so it is important to note again, however, that California's shield laws only protects against search warrants, subpoenas, and witness summons that are related to another state's laws penalizing legally protected healthcare activities. And so these protections do not extend to requests for information or testimony regarding like other valid legal actions, like for example, a malpractice lawsuit. And so for like, what does this mean in practice in terms of these out of protections against out-of-state investigations and prosecutions? We have, like I mentioned, a few hypothetical scenarios to kind of walk through and try to contextualize this information a little bit more. And this particular hypo, for some context, it may sound a little bit familiar. It was actually taken from real events. There is currently a criminal action taken against a California clinician by Louisiana, and Louisiana requested that the California governor extradite the California clinician to Louisiana, and the California governor refused that extradition request. And so it was really important to us to include these hypos based on real world issues that have arisen to really demonstrate why shield laws are so important and how they may apply. And also, just as a quick flag before diving into the hypo, we wanted to flag that as we walk through them, we're talking about these hypos like under one particular category of protection, but this doesn't mean that other categories may not apply. Like there other categories of protections could possibly apply to these same hypos, but we're parsing them out for the sake of clarity and walking through these really complex protections under each specific category. And so for the first hypo, say there's a California clinician that prescribes medication abortion via telehealth to a patient that's located in Louisiana. A criminal action is then brought against the California clinician in Louisiana for violating Louisiana's abortion ban, and Louisiana therefore issues an extradition request to the California governor. And so in this particular case, under Louisiana law, abortion is banned and violations can be punished with criminal penalties. And so in this case, California shield law protections related to criminal investigations and prosecutions would apply in a few ways. So first, California law enforcement cannot arrest the clinician, and the California governor cannot extradite the clinician for providing abortion care that is legal in California. And another way that these protections would apply is that California shield laws also ban state employees from cooperating with the Louisiana investigation. And lastly, search warrants, witness summons, and subpoenas may not be issued related to the abortion care that was lawful in California. And as with all of these provisions, there are a few important caveats to flag. So if the clinician later travels to Louisiana or another state that is, hostile to abortion or gender-affirming care, they could be arrested. And so California only can only protect people within its own borders. And this means that patients and helpers in Louisiana can also be subject to law enforcement action in their home states. And as Conor will explain later, California shield laws provide privacy protections that should prevent Louisiana from gathering information they need to build a case against patients and helpers. But it is important to flag. And then another thing that we really wanted to highlight regarding the provisions related to extradition is that many of the shielding states, so states like California that have passed shield laws, they've included exceptions in their provisions to attempt to avoid constitutional challenges. And so what does that mean? The US Constitution provides that a person who committed a crime in one state, fled, and was found in another state shall be delivered back to the state in which the crime was committed. And this is language taken from Article 4, Section 2 of the US Constitution. And so what this means is that generally it would violate this provision, for example, if California were to refuse to extradite someone who traveled to Louisiana, committed an act that is illegal there in Louisiana, and then subsequently fled to California. But however, it is generally agreed that the Constitution's extradition clause does not cover extradition of people who did not flee. And so what this means is that if the person charged was never physically present in Louisiana, that means that the California governor does not need to extradite that individual. And so these extradition provisions and shield laws were specifically designed to be compliant with the US Constitution. However, given our current climate and how things are going, this may be challenged, and it is a little unclear how these challenges may be resolved. But however, just to reiterate, these extradition provisions were specifically designed to be compliant with the US Constitution. And so moving on to the next kind of big bucket, second category of protections are civil liability protections. And so for this area, there are two general buckets. And the first is protection against the application or enforcement of another state's laws or judgments in California state courts. What this means is that California courts may not apply or enforce another state's laws that allow a civil action against a clinician for performing or providing an abortion or gender-affirming care that is lawful in California. Instead, California law governs actions heard in California state courts against a clinician who provides reproductive or gender-affirming care, and this also includes via telehealth. If the clinician was in California, or any other state where that care was legal at the time of the challenged conduct. And then the second area, and again, we'll go through a hypo to really kind of unpack what this looks like in practice. But the second area is the right to bring what's called a clawback lawsuit to recover damages and costs incurred from abusive litigation. And so what this means is that it refers to a lawsuit that's brought by a person who was the target of an abusive litigation to allow the targeted person to recover damages or obtain other kinds of relief. And so what this means is that a clinician can bring a clawback lawsuit against someone who has engaged in this type of litigation or other legal action that is intended to deter them, prevent, sanction, or punish them based on legally protected healthcare activity. And of course, this includes reproductive healthcare services or gender-affirming care. And so these clawback lawsuits would allow clinicians to recover any damages and costs that they incurred in this litigation. And so again, what does this mean in practice? We have another hypo to unpack what these civil liability protections actually mean in practice. And again, just for some context about this particular hypo, we saw that this category of protections was really important in the Texas case against New York provider Dr. Carpenter. And so in this case, the Texas court issued a civil judgment against Dr. Carpenter In that case, the Texas litigants really tried to enforce that judgment in New York courts, and the shield laws in that situation worked as intended. And so New York's shield laws are similar to California, so you can really see how these protections are playing out in real life. Um, and so for this hypothetical, we have a situation where a California clinician that provides gender-affirming care to a patient traveling from Indiana to California. That patient's parents bring a civil suit in Indiana court against the clinician for violating Indiana law prohibiting physicians or practitioners from providing gender-affirming care to minors. And so in this case, Indiana law prohibits physicians or practitioners from providing gender-affirming care to minors. And an individual who has received that care, so in this case, a patient or their parent or guardian, they can assert a claim to seek damages and attorney's fees. And so the way that California shield laws would apply in this situation is that courts may not enforce any civil judgment that results from the parents prevailing or winning their lawsuit based on providing gender-affirming care that is legal in California. And so in this case, the clinician may file a clawback lawsuit in California to recover costs and damages incurred from that particular litigation. And again, another set of important caveats is that a civil suit or judgment that's filed in Indiana would still have legal force in Indiana. And so um, because of this lawsuit or judgment would still have legal force in Indiana, traveling to Indiana may actually still create risks for that California clinician. And again, these particular shield law protections may also be challenged, and it is unclear how these challenges will be resolved by the courts. And I'll pass it off to you now, Connor.
Great. Thank you, Lorena. Yes, moving on to the next category of protections, you can see that California's shield laws provide lots of protection, lots of categories of protections. This category that I'll be talking about relates to protections regarding professional discipline and restriction of facility privileges. So first, California's shield laws protect California clinicians from revocation or suspension of their license, or from any other type of disciplinary action based simply on the fact that the clinician provided legally protected healthcare activity, including reproductive or gender affirming care. So what this means is that California licensing boards are not allowed to take disciplinary action based on, for example, a civil judgment or a criminal conviction or a disciplinary action in another state that applies law interfering with a person's right to receive reproductive or gender affirming care legal in California. So that's kind of the first type of protection here. The second one around facility privileges is that health facilities such as hospitals are not allowed to deny or restrict a California clinician's staff privileges based on a civil judgment or a criminal conviction or a disciplinary action in another state, again, applying law that interferes with the person's right to receive reproductive or gender affirming care that's legal in California. So that's a lot of words, but like Lorena did, I'm going to give a little bit of a hypo to make this concrete. So this hypothetical specifically relates to professional discipline protection. So in this hypothetical, we have a clinician licensed in both California and Texas, and who provides abortion care to an individual in Texas. And under Texas law, as you likely know, performing an abortion can constitute a first or second degree felony. And the Texas Medical Board generally is required to take disciplinary action against a license holder who is convicted of a felony. So what protections would the California Shield laws provide in this scenario? Well, first, the medical board of California is not allowed to suspend or revoke the clinician's license or impose any other type of discipline on the clinician based on their providing abortion care that's legal in California or based on the Texas disciplinary action. But like Lorena did, I'm going to discuss a few caveats for each of these protections. They are important. So California provides protections against professional discipline by California licensing boards, but a clinician who's licensed in Texas or another state that restricts gender affirming care or reproductive health care may still be subject to professional discipline in those states. So this kind of goes to show that it's important for clinicians to conduct an individualized risk assessment to better understand the risks that they face related to their provision of gender affirming care or reproductive health care, and also their risk tolerance. And we'll get in a little later in the presentation, we'll discuss what that risk assessment could look like. Okay, moving on to the next category of protections in the California Shield laws. These relate to protections of professional liability insurance and protections related to contracts between clinicians and health insurance providers or health plans. So regarding professional liability insurance first, uh, insurers that provide these kinds of policies are prohibited from terminating or refusing to issue or renew a clinician's professional liability insurance or to increase the premium or deductible on those insurance policies simply because a clinician provided gender affirming care or reproductive care that's legal in California. Um, with respect to contracts between clinicians and health plans and insurers, these contracts cannot contain any terms that allow for termination or non-renewal based on a criminal conviction or a civil judgment or professional disciplinary action under another state's laws that interfere with reproductive or gender affirming care in California. So to get into a hypo, um, a hypo that further explains the professional liability insurance protections. Here we have an insurer who increases the premium on a clinician's professional liability insurance policy because the clinician offered gender affirming care that's lawful in California, potentially unlawful in another state. So this would be illegal under California Shield laws. Um, the protections under California Shield laws include prohibiting professional liability insurance providers from increasing the premium or deductible on a clinician's policy just because the clinician provided gender affirming care that's legal in California. Like we discussed earlier, the insurer also would not be able to terminate or refuse to issue the policy or refuse to renew it because of this care that the clinician provided. But got to get into a few of the caveats. Although this is a great protection on paper, it potentially would require some active steps on the part of the clinician to be able to enforce these protections. So, for example, it might look like the clinician having to threaten litigation against the insurer or actually engaging in litigation against the insurer to be able to enforce these protections. Also, the insurer could push back and claim that they're increasing the premium, not because the clinician provided gender affirming care, but for some other unrelated reason. But there are some things that a clinician could do. So if they do experience a potential violation like the one in this hypo, one thing they could do is to seek out pro bono legal assistance, and SoCal Large is a great resource for that. We've dropped that in the chat. We'll keep plugging SoCal Large. Another thing that the clinician could do is to report this potential violation to the California Attorney General's office, and the AG's office has set up an online portal for this purpose, which we also will drop in the chat so you can have it there. And I see just went in. All right. Okay, now moving on to another big category of protections in the California Shield laws, and these relate to privacy of medical information and other data related to reproductive or gender affirming care. And the protections here are quite extensive. So I'm going to go through them, bear with me, and we'll get through. So first, I wanted to talk about um, some of the obligations that the Shield laws impose on clinicians and others. So the Shield laws actually prohibit clinicians as well as healthcare service plans or health insurance plans, contractors and employers from releasing medical information regarding reproductive or gender affirming care in response to a subpoena or request related to an investigation that seeks to impose liability for that care. And at least regarding abortion, these concerns about clinicians and others releasing, this private medical information in response to out-of-state investigations um, are supported by a 2023 study by If When How. And this study was on cases criminalizing self-managed abortions between 2000 and 2020. And what the study found is that provider reporting was actually the most common way that cases came to the attention of law enforcement. Um, Provider reporting actually accounted for 40% of all cases that came to the attention of law enforcement. So it is pretty significant. The second kind of protection, privacy related protection I want to talk about here is also another obligation that applies to businesses that operate electronic health record systems and or EHR systems. And these businesses are required to develop ways to segregate medical information related to reproductive or gender affirming care from the rest of the patient's record. And they also have to develop ways to limit access, like policies and procedures, for example, to limit access and prevent disclosure of this information outside of California. And these requirements are really important because of the interstate nature of electronic health record systems. And without these requirements, something like the following scenario could potentially play out. And this could be, for example, a patient uh, who lives in Texas, who's from Texas, but who travels to California to receive an abortion. And the California clinician who provides the abortion updates the patient's electronic health record to reflect that the abortion happened. And then the patient's physician back home in Texas could then potentially access the patient's electronic health record and report the information about the abortion to law enforcement in Texas. And this assumes that the provider in Texas is participating in the same health information exchange as a California abortion provider, but that very well could be the case because of the interstate nature of these systems. So that's another important protection. The next one is that businesses that provide electronic communication services, such as email or phone services, are not allowed to provide information in response to out-of-state subpoenas, warrants, or other requests related to an investigation of reproductive or gender affirming care. And this protects against real world situations, things we've seen. So there is a Nebraska case, for example, in which law enforcement sent a warrant to Facebook to obtain Facebook messages exchanged between a mother and daughter discussing the daughter's medication abortion. So these protect against real world scenarios. The next kind of type of protection under this category is that at a prescriber's request, mifepristone and other drugs used for medication abortion can be dispensed without the prescriber's name or the patient's name or even the name or address of the pharmacy that dispensed the medication. So we've seen that this type of protection is important because of the case that Lorena discussed earlier on, the Carpenter case, the case in which um, Texas litigants brought uh, brought an action against a New York physician, Dr. Carpenter. And this case actually came to the attention of Texas litigants because Dr. Carpenter's name was listed on the patient's mifepristone bottle. So that those kinds of protections against the identifying information of the provider, the patient being on the actual medication bottle, are also very important. Um, a couple other types of protections to go over here. So prescribing and dispensing both mifepristone and testosterone are excluded from required reporting of patient, prescriber, and pharmacy information under the Controlled Substances Utilization Review and Evaluation System, or CURES monitoring program. Um, California also offers an address confidentiality program for which clinicians, as well as employees and volunteers involved in reproductive and gender affirming care, can be eligible if they face threats from the public or have faced violence from the public. Also, California law restricts the use of geofencing, which is technology that enables the detection of an individual's presence within a specific location, prohibits geofencing around health facilities. And these kinds of protections are meant to shield not only the patient who's seeking care, but also clinicians and the rest of the healthcare provider team. Finally, reproductive health apps are are prohibited from intentionally sharing, selling, or otherwise using the medical information they collect for any purpose other than providing healthcare services to a patient. So I know that's a lot of protections. To get into the next slide here, we wanted to just spend a little bit of time comparing the protections, the privacy related protections under California Shield laws to those found in HIPAA. And just kind of at a high level, many of these provisions in the California Shield laws were put in place in an attempt to plug holes in HIPAA's privacy rules. So just kind of to first set the stage and describe what HIPAA is. I'm sure many of you are familiar with HIPAA, but generally, HIPAA prohibits covered entities, including healthcare providers, that electronically transmit patient medical information, as well as health plans and healthcare clearinghouses. Prohibits these from sharing an individual's identifiable health information, or PHI, to third parties without that individual's authorization. But importantly, HIPAA does contain several exceptions to this rule, and many advocates have raised concerns that healthcare providers may interpret these HIPAA exceptions as allowing or maybe even requiring them to disclose to law enforcement information that could potentially subject patients to criminal investigation or other kinds of legal liability. So in response to these concerns, some states, including California, have added new strong privacy rules in their shield laws. So California includes a provision that prohibits, and when we discussed earlier, a provision that prohibits clinicians, health plans, and others from disclosing medical information related to reproductive or gender affirming care in an action or investigation, and does not contain the exceptions that HIPAA does. Importantly, HIPAA does contain one type of exception that's particularly relevant, and that's the whistleblower exception. And this allows employees and service providers of covered entities to disclose PHI to either an attorney or to the federal government or to a state government if that person has a good faith belief that the covered entity is engaged in some kind of illegal activity or has violated professional or clinical standards. And in the hypo that we'll go over next, I'll discuss that whistleblower exception and some of the concerns there in a little bit more detail. So yes, getting into the hypothetical to to try to further explain some of these privacy-related protections. Here, let's imagine that we have a California clinician who provides gender-affirming hormone therapy, including a testosterone prescription via telehealth to a patient who lives in Mississippi. And under Mississippi law, the provision of most of gender-affirming care is illegal to minors, to people under 18. So let's say that Mississippi law enforcement subpoenas the patient's medical records from the California clinician. What protections does California provide here? Well, first, the California clinician is prohibited from sharing the medical records in response to the subpoena. Also, the electronic health record system used by the California provider is required to develop capabilities to segregate the medical information related to gender affirming care from the rest of the patient's record, and also to limit access only to authorized users and to prevent the disclosure of that medical information outside of California. And the testosterone prescription is not required to be reported under the Cures program. So another note, and going back to that whistleblower exception within HIPAA, first, it's important to make clear that in this hypothetical, HIPAA would not require, it would allow, but not require the clinician to disclose the patient's PHI in response to the subpoena. So the clinician would not violate HIPAA by refusing to provide the patient's PHI in response to the subpoena. With respect to the HIPAA whistleblower exception, this, as I mentioned earlier, allows employees and service providers of covered entities like clinicians to disclose PHI either to an attorney or to the government if they believe that the clinician is engaged in some kind of illegal activity or has violated clinical standards or professional standards. So clinicians should be aware that sensitive patient data is at risk of being shared under this whistleblower exception, even by their own employees or colleagues. And this makes it really important for clinicians themselves to have strong data privacy and security programs. And in our Shield Law guides, we do have more resources for clinicians to consult regarding how to build those kinds of data privacy and security programs. So with that, I will pass it back to Lorena to talk about some additional considerations around the Shield laws.
Thank you, Connor. And I'll be brief. I know we're running close to time here, but we just wanted to quickly flag a few additional considerations that may be of interest to clinicians. And some of these we've already kind of peppered in throughout the discussion, but really wanted to highlight them again. And so one is that we wanted to flag that some of the California Shield laws also protect patients and helpers in many of the same ways that have already been discussed. Another, I think, area that is important to flag is that, as we've discussed throughout the different caveats, there are some legal uncertainties. And because these protections are new and involve conflicts between different laws of different states, they raise important legal and constitutional questions that may ultimately be resolved by the courts. And again, Shield laws in multiple states, including California, they are currently being put to the test by civil and criminal actions. And I know we've discussed a few, but for example, in California, a California physician is being sued for providing abortion care under a Texas law that actually allows for private citizens to file lawsuits against individuals who prescribe, send, or distribute abortion medication to Texas. And so far, California Shield laws are actually working as they intended to protect the doctors from other states' efforts to try to penalize that care. And another thing that we really wanted to just reiterate that we've mentioned before is that California really can only protect people within its borders. And so patients who travel to California for care and then return home, and also California clinicians who travel to hostile states after providing care, are not fully protected by California shield laws, which is really why these limitations and ongoing legal challenges, they highlight the importance of seeking individualized legal advice before attempting to rely on California shield laws. And again, I know we keep doing this plug, but SoCalArch is a great resource. And our shield law guides also highlight various other resources that clinicians can turn to for an individualized risk assessment. And so with that, I'll pass it back to Conor for the final next steps before closing out.
Thank you. Yes, so what we recommend as one of the immediate next steps after, our guides are released and you read through them and digest them, is to conduct an individualized risk assessment in consultation with an attorney. So this would involve the clinician working with an attorney to determine the clinician's individual risk tolerance and their risk exposure as it relates to providing either reproductive and or gender affirming care to patients in California and to other states. So we do have a few of the questions, not a comprehensive list of the questions a clinician and their attorney might want to consider as part of this risk assessment process. So some of them are, what states do you provide reproductive and or gender affirming care in? What states are you licensed in? What types of gender affirming care or reproductive care do you provide? Do you provide gender affirming care to minors? Are you involved in mailing prescriptions to other states? How frequently do you travel to hostile states, given the important caveat that the California Shield laws provide the most protections within California's borders? These are some of the types of questions, and we have a more comprehensive list in the Shield guides themselves. Let me just, next slide. Yes. So we've included a list of some resources here. These are the key legal resources available for reproductive health care and gender affirming care. We've been talking about SoCalArch this whole time. There's also the If, When, How Reproductive Legal Helpline and the Abortion Defense Network that can also provide pro bono legal services regarding reproductive health care. And then on the gender affirming care side, the Transgender Law Center and Lawyers for Good Government also have either legal help desks or other kinds of pro bono legal programs. And we have more resources that will be listed in our forthcoming Shield Law guides when they're released, which will be soon. So that concludes our presentation. We wanted to now move on to the Q&A portion of this event. And I know we only have about 10 minutes, but hopefully that's enough to answer some of the questions that come through.
Awesome. Thank you so much, Connor and Lorena. This has been really, really comprehensive. I know it's a pretty hefty topic because there's so many caveats and bits and pieces that you have to be aware of when you're looking at the laws. So we only actually have about 4 minutes. So if anyone has questions, please drop them in the Q&A. If not, I just wanted to ask one quick question to kind of get us started. So how, with everything that's been in the news lately about mifepristone, with the Louisiana versus FDA case, how have those recent challenges to mifepristone kind of affected the shield laws in California?
Yeah, thank you, Ryan, for that one. I can go ahead and take this. Yes, that has very much been in the news, particularly a case called Louisiana v. FDA has been the one that's reached the Supreme Court and has been making headlines in recent weeks. The bottom line, the key point from this case to take away right now is that mifepristone is still available to patients. It can be prescribed and dispensed without an in-person visit. And this rule is going to remain in effect until a final decision is issued in the case. And the case is, in active litigation in federal court. The core issue in that case, particularly, is regarding how mifepristone is dispensed. And the plaintiffs are really challenging the lifting of the in-person dispensing requirement for mifepristone. but the case does not threaten mifepristone's availability or its FDA approval more broadly. And even if the plaintiffs won in this case, clinicians would still be able to prescribe mifepristone via telehealth, and patients would just need to pick it up in person, such as at a medical office or a clinic or a hospital. Also, it's important to note that there are other medication abortion protocols that will be available via telehealth, regardless of the outcome of this Louisiana v. FDA case, including a protocol that uses only misoprostol. And shield laws will continue to protect the provision of those alternative protocols. Um, and shield laws will also more generally protect the provision of in-person abortion care, which is important to note. One additional resource we just want to plug is that for updates on both this case and other cases and federal actions that may affect the availability of mifepristone, you can check out our mifepristone litigation and federal action tracker, which I believe will also link in the chat, and that's a really good resource. So it's continually updated with the latest developments.
Awesome. Thank you again so much. So it is 8:59 p.m. on the East Coast, so unfortunately we do have to wrap up, but thank you everyone for attending, and thank you again, Connor and Lorena, for all the work that you did on this project. As a reminder, this session is being recorded, so once the recording is available, it'll go out to everyone, and with the finalize know your rights guides on both the gender affirming care and reproductive care shield laws in California. If you have any questions in the meanwhile, please feel free to reach out to Doctors for America. We'll be happy to connect you with resources and potentially the answers for your questions. And again, thank you so much for attending, and I hope you all have a great night.